1. State Department testifies on anti-Semitism, student visa discussions. 2. Rubio's unprecedented visa revocations for protesters face legal scrutiny. 3. State Department memo reveals no evidence of anti-Semitism by Rümeysa Öztürk. 1. State Department testifies on anti-Semitism, student visa discussions. Imagine being a student or professor, only to find out your visa is at risk because of your political views. This is the chilling reality some non-citizens in the U.S. have faced, according to recent testimony from a State Department official. John Armstrong, a senior official in the Bureau of Consular Affairs, revealed in federal court that the State Department held over a dozen meetings with the White House, including Stephen Miller, then President Trump's deputy chief of staff, to discuss student visas. But here's where it gets controversial. These discussions weren't just about visas, they were tied to efforts to combat anti-Semitism, with a definition so broad it included criticism of the Israeli government, support for an arms embargo in Gaza, or calls to end U.S. military aid to Israel. Armstrong's testimony came during a 2-week trial where university professors argued that the administration's attempts to deport individuals over anti-Israel views were aimed at silencing protected political speech. He detailed action memos to revoke visas for students and professors, framing it as a matter of national security. If we get this wrong, we get 9/11, Armstrong warned, underscoring the gravity of the issue. But this is the part most people miss. The process involved a system where the State Department referred non-citizens to Homeland Security for investigation, which then reported back if there was enough evidence to revoke visas. Armstrong admitted that several memos acknowledged the legal risks of tying removal orders to individuals' speech, a direct clash with First Amendment protections. One striking example. Tufts University doctoral student Rümeysa Öztürk, whose visa was revoked after she co-authored an op-ed, participated in an anti-Israel protest, and had a loose connection to a banned pro-Palestinian group. She was detained for weeks earlier this year, her life upended because of her views. Federal Judge William Young has already signaled his stance. Non-citizens, he believes, are entitled to First Amendment protections. Probably they do, he said. We are talking about pure speech. Closing arguments begin Monday, but the debate is far from over. Is it ever justifiable to revoke visas based on political speech, even if it's deemed controversial, and where do we draw the line between national security and free expression? This case isn't just about visas, it's about the very essence of democracy. What do you think? Let's hear your thoughts in the comments. 2. Rubio's unprecedented visa revocations for protesters face legal scrutiny. A shocking revelation, U.S. officials quietly warned that stripping visas from campus protesters could be legally explosive, and they did it anyway. But here's where it gets controversial. Secretary of State Marco Rubio tapped a rarely used power to revoke student visas, knowing full well judges might balk at treating political speech as deportable conduct. In federal court last Friday, a senior government witness lifted the veil on an internal memo cautioning that Rubio's move under the Immigration and Nationality Act, specifically, the clause allowing visa revocation if an individual's presence would have potentially serious adverse foreign policy consequences, had never been tested in court. As the memo bluntly put it, it is likely that courts will closely scrutinize this determination, because much of the protest activity at issue could qualify as protected speech under the First Amendment. And this is the part most people miss. These revelations came amid a bench trial challenging what critics call a constitutionally dubious policy of ideological deportation aimed at pro-Palestinian demonstrators. Among those named are Columbia University graduate students Mahmoud Khalil and Mohsen Madawi, and Tufts University student Rümeysa Öztürk. The lawsuit, brought by the American Association of University Professors and the Middle East Studies Association, accuses the Trump administration of weaponizing immigration law to punish dissent. According to testimony from John Armstrong, a senior official in the State Department's Bureau of Consular Affairs, an action memo recommending visa revocation for Khalil and another student, Yunseo Chung, was blitz-approved by 10 different offices, including the White House, the Departments of Homeland Security and Defense, within 24 hours. In all, over 20 high-level discussions took place in March alone. Armstrong even spoke directly with members of the Homeland Security Council, naming advisor Stephen Miller and his deputy as active participants. Rubio's personal two-page memo accused Khalil of leading anti-Semitic protests and disruptive activities that allegedly fostered a hostile environment for Jewish students. When asked how officials define anti-Semitism, Armstrong admitted he could not recall receiving any formal guidelines or training. His informal rule of thumb: anyone claiming to criticize Israel rather than Jews is simply masking true hatred, a judgment he described as a dodge by anti-Semites. Support for a designated terrorist organization like Hamas. That, Armstrong stressed, is an automatic ground for visa revocation. Yet under the same executive order, he conceded that a wide array of speech, criticizing Zionism, condemning Israel's actions in Gaza as genocide, chanting "from the river to the sea," labeling Israel an apartheid state, or demanding an arms embargo, could also trigger removal proceedings. Armstrong personally authorized Öztürk's visa cancellation, citing her protests against Tufts University's ties to Israel and her alleged association with Tufts Students for Justice in Palestine, a student group now banned on campus. Even after Homeland Security investigators determined she took no part in the banned group's activities, Armstrong maintained she had sufficient connections to justify revoking her visa under a broad statutory provision that allows cancellation for virtually any reason. Meanwhile, Andre Watson from Homeland Security's National Security Division revealed that since the creation of a special Tiger team targeting student demonstrators, he has referred 10 to 15 students for possible visa cancellations, including all those reported on by Homeland Security investigations. And here's the courtroom twist: U.S. District Judge William Young told both sides that he views criticism of Israel, even harsh allegations of war crimes or genocide, as protected political speech. He reminded everyone that anti-Semitism, while deplorable, is not illegal under the First Amendment, and suggested that visa holders and lawful permanent residents likely enjoy the same free speech rights as U.S. citizens. He firmly stated that criticizing Israeli government policy does not equal supporting Hamas. Closing arguments are expected once new evidence is introduced, leaving us with a pressing question: is this an overdue defense of free expression on campus, or a dangerous overreach by the state? What do you think? Should dissenting views on foreign policy be grounds for deportation, or is this a red line we must not cross? Share your thoughts below. 3. State Department memo reveals no evidence of anti-Semitism by Rümeysa Öztürk. Boldly put, the debate over academic freedom and national security has never been more intense, with the recent case of Tufts University PhD candidate Rümeysa Öztürk thrusting these issues into the spotlight. But here's where it gets controversial. A memo from the U.S. Department of State reveals that no evidence links Öztürk to anti-Semitic behavior or terrorist support, despite her arrest and visa revocation. This surprising detail emerged during a federal court hearing in Boston, shedding light on the complexities surrounding her detention. The Federal Department of Homeland Security found no proof that Öztürk, a Turkish doctoral student focusing on child development, engaged in any anti-Semitic acts or publicly endorsed terrorism. This information was disclosed in a confidential State Department memo, reviewed under strict court supervision on the final day of testimony in a lawsuit filed by educational organizations like the American Association of University Professors. The suit challenges the former Trump administration's policies that led to the detention and arrest of international students involved in pro-Palestinian activism. Öztürk's arrest took place in late March on a Somerville street, where she was apprehended unexpectedly by plainclothes immigration agents wearing masks and swiftly transported to a detention center in Louisiana. Authorities are seeking her deportation. Yet, her lawyers insist the real issue lies not in any illegal activity, but in her protected speech, specifically an op-ed she co-authored in Tufts student newspaper advocating for Palestinian rights. John Armstrong, a senior official at the State Department's Bureau of Consular Affairs, testified that he made the decision to revoke Öztürk's visa. However, under questioning by Alexandra Conlon, an attorney representing the plaintiffs, Armstrong had to acknowledge the existence of a State Department action memo. This document, drawn from findings by DHS, clearly stated that there was no evidence linking Öztürk to anti-Semitic behavior or terrorism. Öztürk's defense attorney, Masa Kanbabai, described the day's testimony as mesmerizing, emphasizing that the government presented no concrete proof of any wrongdoing on her client's part. Kanbabai argued that the case reflected a blatant attempt to punish Öztürk for voicing political beliefs rather than any legitimate immigration concern. Her detention is less about protecting national security and more about retaliating against her right to free speech, she stated. At the time of her arrest, the Department of Homeland Security issued a statement accusing Öztürk of supporting Hamas, a designated terrorist group responsible for violence against Americans. They justified the visa revocation as a security measure, asserting that visas are privileges that can be rescinded for actions glorifying terrorism. Yet, the absence of evidence highlighted in the memo raises critical questions about the fairness of this claim. Throughout the trial, it became evident that Öztürk's case is part of a larger federal effort to surveil and suppress student activists of Palestinian causes on university campuses. Others named in the lawsuit include Columbia University students Mahmoud Khalil, Mohsen Madawi, Yunseo Chung, and Georgetown postdoctoral scholar Badar Khan Suri. Revelations came to light that the government heavily relied on Canary Mission, a controversial pro-Israel website that tracks pro-Palestinian activists, to identify and target these individuals. In a particularly striking testimony, a Boston ICE official confirmed that Öztürk's arrest was prioritized by supervisors, an unusual directive during his long career, pointing to a targeted crackdown on pro-Palestinian voices. Armstrong also testified that Öztürk's visa revocation was based not only on her op-ed, but also on her participation in protests against Tufts' ties to Israel, actions he claimed moved beyond free speech. He alleged she was connected to the Tufts Students for Justice in Palestine group, which he described as fostering a hostile environment for Jewish students and supporting terrorist organizations, though he did not provide direct evidence of her involvement. Armstrong admitted the case was nuanced and required careful deliberation. Revoking a visa is a serious decision, he stated, adding that he spent considerable time reviewing the situation. After nearly 6 weeks detained in Louisiana, a Vermont judge ordered Öztürk's release as she continues to fight her deportation. The circumstances of her arrest and detention attracted international media attention, sparking debate over the limits of free expression, especially for international students in the United States. This case challenges us to grapple with difficult questions. When does criticism of a foreign government cross lines of security? How do we balance national security concerns with the protection of free speech, especially on campus? Are we fair in targeting activists, or are political biases influencing enforcement actions? These questions remain hotly debated and invite readers to share their perspectives. Do you think government agencies overstepped by arresting Öztürk despite a lack of evidence? Or do you believe national security concerns justify stringent scrutiny? Join the conversation and let us know what you think.